All right. I will call this session of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Harris, Senator Orenshaw, Senator Dondero Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here. Thank you so much. All right. Thank you all for bearing with us and having patience as we finished up our floor session. Today we have a number of bills on work session and 3 bills to hear. It's my intent to start with the work session and then hear the bills in order. As always, if you need something taken out of order, please just try to let us know and we'll do our best to accommodate. I do have 3 bills, AB 126, AB 159, and AB 227 on a consent calendar. Which we would normally start with. So if we have any issues after Mr. Guyton goes through the work session documents, we can break them out into separate votes, but I'll let Mr. Guyton go through them first.
Thanks, Chair. Pat Guinan for the record. As the Chair mentioned, we have 3 bills on consent calendar for the work session. We'll start with those. I'm going to try to go through these quickly because I know we've got a lot to do today. Assembly Bill 126, sponsored by Assemblyman Wynn and Senator Wynn, is an omnibus business entity measure. It's brought by the business bar every session. I won't go through the full summary of it. There are no amendments, and I believe that Mr. Kim and others are here in the audience if there are actually questions. The next bill, AB 159, is sponsored by Assemblyman O'Neill, Assemblywoman Dickman, and others. We heard it here on the 15th. This is a bill relating to cruelty to animals. We just heard it in committee the other day. It revises some penalties for those who are convicted of cruelty to animals. I see the Assemblyman here if there are questions. And then the third and final bill on the work session consent calendar is AB 227, which was sponsored by Assemblywoman Cohen. It creates summary procedures for marriage annulment and child custody under specific circumstances. And I'll just leave it at that, Chair. That's all that is for the consent calendar.
All right. Any questions on any of those 3 bills? All right. I don't see any questions, so I would accept a motion to do pass. All right. There's a motion from Senator Wynn, a second from Senator Dondero Loop. Any discussion on the motion? Senator Orenshaw.
Thank you. I'm going to support all 3 out of committee. Just on 159, I appreciate the Assemblyman's hard work. I just have a couple of questions. I'm just going to reserve my right on 159.
Understood. Thank you. Anybody else? All right. In that case, all in favor say aye. Aye. Any opposed, nay. They are unanimous votes to do pass those 3 bills. I'll take a volunteer for the AB 126. Senator Wynn, you'll be the AB 126 floor statement. I'll take a volunteer for AB 159. I'll give that one to Senator Krasner. And a volunteer for AB 227. That one will go to Senator Orenshaw. And that takes us to AB 75 on the work session. Mr. Guinan.
Thanks, Chair. All right, Assembly Bill 75, sponsored by Speaker Yeager. We heard this bill here on the 8th of May. This bill authorizes the adoption of regulations to establish requirements for transactions involving an offer to sell or the sale of a security to a Nevada certified investor. I don't know if I need to go through this entire summary, Chair, unless you want me to. I could just speak to the amendments. Okay, there are 2 amendments proposed. The first is from the Secretary of State. It's a friendly amendment that is here for your review. The intent of the amendment is to restore registration by qualification provisions that are found in NRS 90.490 and the registration fee found in NRS 90.500 for all other securities outside of the framework for sales to certified investors. And secondly, Speaker Yeager offered a second amendment that is also attached. It's in response to a suggestion from Senator Harris during the hearing on the bill. It adds provisions to modify the definition of a Nevada certified investor as it pertains to couples by adding language in section 2.1b to provide that a certified investor must have reported an income on the federal income tax return for the immediately preceding calendar year that exceeds the greater of either the median household income or $100,000 for filing as an individual person or $150,000 for filing as a couple. That's all I have on that one.
Any questions on this bill? Senator Harris.
Thank you, Chair. Not a question, just a comment. I wanted to thank the Speaker for taking into consideration the comments that I made during the hearing and proposing an amendment to address that. Very much appreciated.
All right, I don't see any other questions or comments at this time, so I would accept a motion to amend with both amendments and do pass. All right, Senator Nguyen moves to amend, do pass, and Senator Harris seconds. Any discussion on the motion? All right, not seeing any. All those in favor say aye. Aye. Any opposed, nay. The motion carries to amend, do pass. And I will take a volunteer for the floor statement named Senator Nguyen. And that takes us to AB 356. Before I hand it over to Mr. Guinan, I just want to clarify for everybody the special circumstances. There has been an amendment proposed by a member of the Assembly who's not a sponsor to the bill, but I understand that the sponsors are accepting her amendment. So I've gone ahead and included it in the work session document for everybody's consideration. And with that, I will hand it over to Mr. Guinan to walk through the work session document and the amendment.
Thanks, Chair. All right, this is Assembly Bill 356 in the first reprint. The sponsors of the bill are here, Assemblymember Dickman, LaRue Hatch, Anderson, Hansen, and others. We heard it here on May 5th. Assembly Bill 356 provides that a person commits the crime of unlawful installation of a mobile tracking device if the person knowingly installs, conceals, or otherwise places a mobile tracking device in or on another person's motor vehicle without the knowledge and consent of the vehicle's owner or lessor. A person who violates these provisions is guilty of a misdemeanor for the first offense, a gross misdemeanor for the second, and a Category C felony for a third or subsequent offense. These provisions do not apply to a law enforcement officer who installs, conceals, or otherwise places a mobile tracking device in or on a motor vehicle pursuant to a warrant or a court order. The amendment the Chair just mentioned is offered by Assemblywoman Miller, and it is friendly, as we just heard. The amendment replaces the word law enforcement officer with agency, so it would read law enforcement agency, and then clarifies that the bill's provisions do not apply to a law enforcement agency that installs a tracking device in accordance with all applicable requirements of the United States Constitution, the Nevada Constitution, and the laws of this state. And the amendment is attached for review, Chair.
All right, any questions on this bill or the amendment? Senator Stone?
Thank you, Madam Chair. I was just going to comment. I really appreciate the amendment. That was a stickling point for me, and with that, I'm going to go from a no to a yes, and appreciate the work of the authors and bringing the amendment forward. Thank you so much, Madam Chair.
Okay, Senator Hansen.
Actually, I was going to wait the right time, but that's okay if you want to talk about it now. First of all, I wanted to thank the chair for a really robust, fascinating discussion. We raised the awareness and, frankly, in my opinion, the appreciation for the Bill of Rights. And I was delighted to see so many members of this committee who really worked hard to make sure that we protected those constitutional rights. And so the discussion, I've been on this committee for 7 terms. That was probably one of the very best discussions I've ever heard, seriously. And it was fascinating hearing all the give and take on it. And frankly, I was okay with the bill as it was after hearing Mr. Pirro and the prosecution side. So I haven't had a chance to actually read the new amendment, but it sounds, we're still basically saying that we're going to make sure that whatever our law enforcement community does, it's going to be in full compliance with the essential provisions of the Bill of Rights. So with that, I'm in strong support of AB 356. Thank you, Madam Chair.
All right, thank you. Any other questions or comments at this point? If not, I will take a motion to amend and do pass. All right, we have a motion from Senator Nguyen and a second from Senator Stone. Any discussion on the motion? All right, not seeing any. All in favor say aye. Aye. Any opposed, nay. All right, it unanimously carries to amend and do pass AB 356. And is there a volunteer? I will assign the floor statement to Senator Hansen. And with that, we move on to AB 371.
Thanks, Chair. Okay, Assembly Bill 371 in its first reprint. This is a bill that relates to parentage. It was brought by Assemblywoman Cohen and others. We heard it here on the 10th of May. It enacts provisions of the Uniform Parentage Act governing parentage and the establishment of parent and child relationships. And among other things, the bill revises provisions relating to proceedings to adjudicate parentage, assisted reproduction, and gestational agreements. And the State Board of Health is authorized to adopt regulations relating to an acknowledgement or denial of parentage. The bill also establishes provisions governing genetic testing and proceedings to adjudicate parentage, and revises provisions relating to assisted reproduction and gestational agreements, and does some other things. I'll stop there, Chair, unless you want me to keep going. There are two amendments proposed to the bill. They're both friendly. The first is from Kimberly Surratt, and that one removes the term surrender regarding a surrogacy arrangement to eliminate any confusion over parental rights, and it adds the phrase, acknowledge the intended parents are the legal and physical custodians of the child, where appropriate in the bill. That amendment is attached, as is the other. The second amendment is from Clark County. It's also a friendly amendment, and it makes the following relatively minor changes to the bill. First, it permits the registrar of vital statistics to release information relating to an acknowledgement or denial of parentage to an agency which provides child welfare services. It clarifies that a child welfare agency may maintain a proceeding to adjudicate parentage in accordance with Chapter 432B of NRS. It provides that the venue for a parentage action brought pursuant to that chapter is in the county in which the action is commenced, and it provides that a court may combine a proceeding to adjudicate parentage with a proceeding for the protection of a child from abuse and neglect under that same chapter. These amendments do not conflict with each other, and the committee can take one, both, or neither.
Okay, thank you. Any questions on the bill or the amendments? Did you want to say anything? You don't have to. Okay. Just checking because we have two different amendments. See no questions on the bill. I would accept a motion to amend, do pass. All right. So moved by Senator Orenshaw, a second from Senator Wynn. Any discussion on the motion? Senator Hansen.
Thanks, Madam Chair. I reluctantly am going to have to vote no on this. I'm very uncomfortable with the gender-neutral language that's in it. While I agree that the section of the NRS needs some cleanup, I think this bill goes much too far, so I will be a no.
All right. Any other discussion? Senator Krasner.
Thank you, Chair. Seeing that we've just received two amendments to the bill, I will vote yes to get it out of committee, but want to reserve my right to change my vote prior to floor. Thank you.
All right. Any other discussion? Not seeing any, we will take a vote. All those in favor, aye. Aye. Any opposed, nay. All right. Nays are Senators Hansen and Stone. The rest are ayes, and the motion carries to adopt both amendments and pass the bill. I will assign the floor statement to Senator Harris. And that takes us to AB 373.
Thanks, Chair. Assembly Bill 373 in its first reprint was heard here on the 15th of May. Assembly members Gorlow, Wynn, and others are the sponsors. It revises provisions relating to deceptive trade practices. If the Attorney General has reason to believe that a person has engaged or is engaging in a deceptive trade practice, the bill authorizes the Attorney General to obtain appropriate relief, including the recovery of a civil penalty, disgorgement, restitution, or the recovery of damages as parens patriae. The bill increases from $12,500 to $25,000 the additional maximum civil penalty for each violation if the deceptive trade practice was directed toward an elderly person, and from $5,000 to $15,000 the civil penalty that may be recovered if the court finds that a person has willfully engaged in a deceptive trade practice. The bill also requires an indictment for any offense involving the commission of any deceptive trade practice that is punishable as a felony. And the Attorney General's office has offered an amendment that is friendly, and it's attached to this document for your review. It does the following things. In Section 1, it adds language clarifying the Attorney General's ability to bring an action under the bill's provisions. It raises the civil penalty for a deceptive trade practice directed toward a disabled person from $12,500 to $15,000, and it adds a new section to the bill to increase the civil penalty for a deceptive trade practice directed toward a minor from $12,500 to $25,000. That's all.
All right. Any questions on AB 373 or the amendment? I don't see any questions, so I would accept a motion to amend and do pass.
Move as amended, do pass.
All right, we have a motion from Senator Stone and a second from Senator Wynn. Any discussion on the motion? Not seeing any discussion. All those in favor, aye. Aye. Any opposed, nay. Okay, unanimously carries to amend and do pass, and I will assign this floor statement to Senator Stone. And I believe that brings us to the conclusion of our work session. Thank you all for being here and bearing with us. We'll now move into our first bill hearing for the afternoon on AB 193. I will open up that bill hearing and invite the presenters up to the front table to begin whenever you are ready.
Good afternoon, and thank you, Chair Scheibel and members of the committee. For the record, my name is Cecilia Gonzalez, and I represent Assembly District 16 in the Nevada Legislature, and I'm here today to present to you Assembly Bill 193. To help me present is Nathaniel Erb, the state policy advocate from the Innocence Project, and District Attorney Vern Pearson from the El Dorado County in California, which is just over the border from Washoe County, so very close. I'm going to give a brief overview, and then with the chair's permission, I'm going to kick it to them to continue the presentation. Police officers have a legal and ethical responsibility to uphold the law and protect the rights of all individuals, including children in custody. Lying to a child in custody can violate these responsibilities and potentially harm the child's well-being. Children who are in custody are often vulnerable and may already be experiencing high levels of anxiety and stress. And lying to them can create and exacerbate these feelings and may lead to fear, confusion, and mistrust. Assembly Bill 193 prohibits a peace officer or other person authorized to conduct a custodial interrogation of a child from providing false information about evidence and making promises of leniency or advantages to a child during a custodial interrogation. Before I kick it off, I do just want to note for the committee, this is kind of like a hot topic right now. Currently, there are 4 states, and actually I think 4 or 5 states, including ours, that are currently having this conversation in their state legislatures, and in the last 2 years, 3 to 4 other states have passed this as well. And so it is something that Nevada can be on having this conversation and be on the forefront of this issue as well. And with that background information, I am going to hand the presentation over to our Zoom presenters. Thank you.
Thank you. Good afternoon. For the record, my name is Nathaniel Erb, here on behalf of the Innocence Project, which represents people who have been wrongfully convicted. Reviewing all cases of wrongful convictions that have been revealed to date, it's clear that there continues to be an issue of courts and juries not identifying and excluding false confessions. It is the most common contributing factor in homicide exonerations and is present in 30% of all DNA exonerations. 3 of the 4 wrongful convictions in Nevada where false confessions were identified were homicide cases. False confessions have caused finders of fact to ignore alibi evidence and contradictory issues in a case in the same manner as false or misleading forensic evidence and false eyewitness statements tend to cause them to do. However, confessions are not often given the same legal scrutiny as these and other types of evidence because there's pervasive belief that one would not confess to something they did not do. For the Innocence Project, the question has been what continues to cause false confessions and what has permitted them to be used to convict innocent people. Law enforcement, prosecutors, and those that represent the innocent have independently come to the same conclusion that manipulating suspects through lies and about evidence and leniency is a leading concern. The federal government created the High Value Detainee Interrogation Group in 2009 and tasked it with identifying the most effective methods for investigating terrorist threats. It identified that these types of tactics, while sometimes permissible and useful, carry great risks and do not produce reliably accurate information. Further, it identified more reliable techniques that are now the core trainings of the Federal Law Enforcement Training Center. Later, in 2014, the International Association of Chiefs of Police published the first modern guide on interrogating juveniles and explicitly recommended using these tactics. As well, national law enforcement trainers have begun to end their teaching of these tactics across the country. While proactive adoption of better techniques has begun, there still remains a need to heighten legal scrutiny in cases where law enforcement feels deception is necessary. The U.S. Supreme Court has ruled that these types of tactics are not per se barred. Its rulings have not expressed the validity or need for these tactics and have often called them directly into question. But its rulings have stated that it is a role of state legislatures to create rules of evidence addressing this issue. In response to this, now 8 states have passed laws barring or heightening the scrutiny of statements derived through the use of lies about evidence or leniency. This bill provides this slightly heightened scrutiny by requiring an analysis of reliability in addition to voluntariness under the current judicial standard. Nationally, that would be one of the more lenient laws of other states, since some create an outright per se bar and others have a heightened legal standard. But we still believe this would be an important analysis to inject into the process. And I'm happy to answer any questions about how other states have addressed this, but I'll turn it over to my colleague, Vern.
Good afternoon. My name's Vern Pearson. I've been a prosecutor for more than 30 years. I am the elected district attorney in El Dorado County, as I have been for the last several years. I'm the former president of the California District Attorneys Association, the author of the California Evidence Pocketbook. I bring that up because I am not an expert. While I'm an expert on California law and California criminal evidence and procedure, I am not an expert on Nevada law. I'm also, I think, fairly characterized as someone who knows an awful lot about the science of interrogation and interrogation training over the last 70 years. And what's happened over the last 70 years, I should say. My concern here in talking to you is primarily focused on the use of deception. And I understand the bill bans the use of deception as it relates to juveniles. But more broadly, I would say that the important thing to note is that while the primary training that's occurred here in the United States over the last 60 to 70 years has employed the use of deception, what we know from an extensive amount of research that's been done by the HIG, by the UK counterterrorism police and others, as well as here in the state of California, is that it's unnecessary to use deception in the interview room. I've been a prosecutor. My entire time as a lawyer, I've been a prosecutor. My motivation is to hold guilty people accountable for their actions. But at the same time, I think we have an ethical responsibility to ask ourselves, do we think it's a good idea for police officers to knowingly lie to a child in order to get a child to tell the truth? And I would submit to you as the longtime former chair of the DA's Association here in California's Ethics Committee, I think we have an ethical problem, and we have one in society when we say it's okay for police officers, and we're not talking about undercover investigations, we're not talking about what's called Perkins operations, things like that. We're talking about in the interview room where everyone knows who everyone is, and for an officer to intentionally lie to someone. Again, the reason why I say it's not necessary, for the last 4 years, I'm sorry, it's blurred here. Over the last 4 years, my office and throughout California, we've begun the process of training officers on a methodology that was largely developed by the HIG, which is based upon rapport and speaking to people in a way that's slightly different than what's been done in the past. But just so, and this way, the research says the way that we're talking about and training people is more effective than deception and dishonesty. Let me just briefly close with this. And unfortunately, I don't know why it's on blurred. This is the book entitled Anatomy of Interrogation Themes. This is the most prevalent training technique that's been used in the United States. Over 500,000 officers have been trained on this. And one of the chapters talks about, or one of the sections talks about how to develop a theme to talk to a juvenile. But let me use an extreme example out of this book that's throughout the United States used as well as in Nevada and previously in California, talking about, and again, this is an extreme example, a man who's been taken into custody for sexually assaulting his 11-year-old stepdaughter. Before going into the interview, this is a quote, "An important procedure for the investigator to follow prior to any interrogation is to select at least 5 reasons why the subject may be justified in sexually assaulting an 11-year-old, in committing the act, and 5 ways the interrogator can minimize the subject's behavior." This is what's been trained to law enforcement over the last 60 years. They've come to believe that it's necessary to lie to children and to adults in order to get them to tell the truth. That's the type of lies that we're talking about, justifying the sexual assault of an 11-year-old. It's bothered me during my entire career. I personally experienced what it's like to reinvestigate a case where a person was wrongfully incarcerated for 14 years for a murder he had nothing to do with. And it's time that we change this practice, and I'm happy to answer any questions, and thank you for your time and consideration.
Thank you so much. Madam Chair, I also just wanted to note that there is a proposed amendment from the District Attorney's Office. We have not accepted it at this time, and I imagine that it'll be part of the conversation today. Thank you.
Thank you, and thank you for reminding me. I did have a chance to review the District Attorneys Association's amendment, and I will allow them to come up after your presentation to talk a little bit about the amendment and answer questions. For now, let's go ahead and, are we ready to open it up for questions on the bill in its original form? Senator Orenshaw.
Thank you, Chair. Thank you, Assemblywoman, for bringing the bill. My question to the two presenters on Zoom: have you found that in your research and in your career as a prosecutor, that when children have been arrested and false statements have been made to them, whether it's something like, we have you on video, or your friend gave a, complete confession and said that you did it, or something like that, have you found that that has produced false confessions from that child in either your career or in your research to the gentleman from the Innocence Project and to the prosecutor?
Thank you for the question. For the record, Nathaniel Erb on behalf of the Innocence Project. We certainly see it across our cases that that's the case, both for children especially, but also adults, fully functioning adults, that when people are lied to about evidence, particularly in the pressures of the interrogation room, not only do folks make reasonable choices where we've had cases where folks are told that there's bloody handprints, that they have their DNA and they're going to test it and show that you're innocent, so the person confesses to get out of the interrogation room because say, oh gosh, if we got that evidence, you're going to clearly show that I'm not the right person, I just want to get out of here, only to find that they've then confessed to the crime and there's no evidence to test to prove their innocence, and they spend 14 plus years trying to prove that. Or even in the case of children, and this is covered by the International Association of Chiefs of Police training manual back in 2014, that when you pressure kids in this way, they can even adopt those facts and start to believe that they actually committed the crime, that they have the trust in law enforcement that they wouldn't lie to them. So if the law enforcement officer says that they did it, they start to believe that, and it can overboard the will of the person. That has been a common theme in the research by interrogators and researchers independently, that why these tactics are inherently dangerous. And I'm sure Byrne might also have some thoughts.
Yeah, the case that we were involved in, the case that we reinvestigated and exonerated someone that was, she was an adult at the time. But we know from the way child development research has been done that if it's true with adults, it's certainly more true with children. I have not personally been involved in that type of a case, specifically where a juvenile has been lied to and then falsely confessed. Although I am aware of a number of published cases that such as that has been the case. But again, I think it's important to stop and think about it. And when I've spoken to some people, both in the state of Nevada as well as here in California, and I asked the question, I said, inherently, think about what you're asking. The question is, do we think it's okay for an adult trained police officer to intentionally lie to a child in order to get them to tell the truth, particularly if it's not necessary and the science and research says that is not a reasonably reliable way to get a truthful statement out of a juvenile or in fact an adult. So with that, thank you.
Thank you, Chair. And would you indulge me in a brief follow-up? Thank you, Vice Chair. And I'm not sure if it's for Mr. Erb or for the District Attorney from El Dorado County, but you mentioned 8 jurisdictions that have passed similar statutes to either forbid making false statements to a child in custody during interrogation or have heightened scrutiny. And I just wonder if either of you know, in those jurisdictions, are you aware of subsequent problems that have arisen for law enforcement, for prosecutors, due to that restriction on making false statements? Is there anything showing that cases that should have gone forward weren't able to go forward? Is there any data or any studies like that?
Thank you for the question. For the record, Nathaniel Erb here on behalf of the Innocence Project. Yeah, it's a great question. There have not been any cases. Actually, the first instances of these laws in Illinois and Oregon, first in Illinois, were written directly with prosecutors' offices and law enforcement. It was supported unanimously by all of the agencies there. That has continued to be the case. The language has been tweaked over the years slightly, but it all goes back to that same basis of legislation that was written directly with law enforcement and prosecutors. The original version of AB 193 was introduced in the same form that Utah enacted the law, and its law was also endorsed by every single law enforcement agency across the country and across the state and all the prosecutors' offices. So we haven't heard of any instance. Every single state that I've worked on this issue, I've worked closely with law enforcement and prosecutors, and this mirrors that same language, but with some extra caveats and carve-outs in case of exigent circumstances and making sure that we're talking about materialized the evidence that other states do not have.
Thank you very much, Mr. Erb. Thank you, Vice Chair.
Committee members, additional questions? Senator Krasner.
Thank you, Vice Chair. Thank you, Assemblywoman, for your presentation. I think my question is for one of the two presenters on the Zoom call. So there's two questions. Is it currently legal in Nevada for law enforcement to lie to a child while in their custody or during custodial interrogation?
Cecilia Gonzalez,
Thanks for your
District
question.
16, for the record, yes.
Okay. And for the two presenters, why is this allowed? What is the rationale for allowing law enforcement to lie to a child when children are taught police are your friend, there to protect and serve? What's the rationale for this?
Senator Krasner, we have an amendment proposed by the Nevada District Attorneys Association. Yep, I'm going to actually bring them up to discuss their amendment, and I'm thinking your question may be better suited for them.
I'd like to hear what the District Attorney for California has to say. Thank you.
Sure.
If I may, please, Madam Chair.
Absolutely. I would also encourage you to ask that same questions of the Nevada District Attorneys as well.
Okay.
Well, thank you. I appreciate the question, and I do. In terms of Nevada law, I'm going to defer to the Nevada DA's association specifically. But the question, as I understood it, was why is it that we've been training officers this way for the last 60 years? Well, I mean, frankly, the best way I can put it was we were back in the time period when this type of methodology and technique was developed. We have to recognize that there was law enforcement practices were very aggressive and physical with interrogating people. So this type of psychological coercion as opposed to physical coercion was seen as a step forward at that point, 60 to 70 years ago we're talking about. However, over the last 70 years, or increasing over the last several years, it's been more of a marketing campaign. In other words, detectives are told, this is the best way to go in and get an interview. This is the best way to secure a confession. And the training programs, significant amount of marketing, significant amount of money involved in it, are built around teaching officers how to use pseudoscience to detect clues on whether or not someone's telling the truth or not. And whenever you determine that they're not telling the truth, then you will switch to an interrogation mode where you repeatedly cut off the individual and steer them back to what you believe to be the truth of the matter being investigated. Significant amount of marketing, a lot of money to be made in that field, training a lot of officers throughout the United States, and that's really the reason. Fortunately, since the creation of about almost 15 years ago now of the HIG has spent millions of dollars on behalf of the United States researching whether or not these types of methodologies actually work. The UK spent a significant amount of money looking at it. It sounds really good. It sounds like it's a trick. It sounds like a way of getting to the bottom of things. The research says it doesn't actually work, and that when you convert to a rapport-based interviewing style, which essentially is not being nice, but is treating the person like a human, there is significantly more yield that comes out of it. It's not sexy, it's not glamorous, but it is the practical reality of what works, as opposed to what is a product of a marketing campaign.
And if I can add, Cecilia Gonzalez, go ahead.
1 second, Assemblywoman. If you could, sir, the DA from California, if you could just put your name on the record again quickly.
Oh, I'm very sorry. My name, again, is Vern Pearson, Pierson. I'm the elected district attorney in El Dorado County, California.
Thank you, sir, and we'll need you to do that each time you speak. Assemblywoman Gonzalez.
Yes, thank you. And I just wanted to add too, right, like if you look at the criminal justice system historically, right, we had a lot of like tough on crime, right, during the 60s, 70s, and 80s, right? And so it was, there's been a lot of police violence throughout the years that we are now coming to the table to talk about how these policies don't work, right? And so that's part of the conversation, the historical context. Thank you so much for the question.
Additional questions? Okay, not seeing any, this is a time where we'll invite up the Nevada District Attorneys Association to discuss their amendment. All right, Ms. Noble, go ahead and begin when you're ready.
Good morning, Vice Chair. Good afternoon, Vice Chair Harris and members of the Judiciary Committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. I want to start sort of where we left off with Senator Krasner's question, if I may, because I think it's an important one to clarify. Like the lawyers on this panel know, often when you ask a question in the law, there's not a clear yes or no answer. The case on point in Nevada is Sheriff versus Bessie, and it can be found at 112 Nevada 322. In that case, the police used a falsified report during the interrogation of a minor. And in evaluating whether or not to admit portions of that minor's confession, the court, like it does with adults, like it does like the United States Supreme Court does, did a totality of the circumstances evaluation, and it also looked at the falsified report, the nature of the confession, and whether or not the false evidence that was presented during that interview was likely to produce a false confession. So Bessie indicates that it's disfavored generally in Nevada, but also acknowledges that there are circumstances in which it may be used, and we may have admission of subsequent statements. That is the state of the law in Nevada. That's the only case we have on point.
Thank you, Ms. Noble. What are those circumstances? So you said it is generally disfavored to lie to children, to have law enforcement lie to children while in custody during custodial interrogation, but there are exceptions. What are the exceptions, please?
Thank you for the question, Senator Krasner. Jennifer Noble for the record. As with any case involving the voluntariness of a statement, there are not enumerated exceptions, but that fact that deception was used is part of the court's overall analysis regarding the voluntariness of the confession. So during our extensive discussions on this bill, it was uncontested by any stakeholder that we have no examples in Nevada of wrongful convictions of juveniles arising from the use of deception during a law enforcement custodial interview. But to answer your question, Senator Krasner, whenever we are considering the voluntariness of a suspect's statement during a custodial interview, whether an adult or a child, both the United States Supreme Court and the Nevada Supreme Court conduct a fact-specific inquiry and consider the totality of the circumstances. Factors include, but are not limited to, the youth of the accused, their lack of education or low intelligence, the lack of any advice of constitutional rights, the length of the detention, any repeated and prolonged nature of questioning, and the use of physical punishment such as deprivation of food or sleep. And in Nevada, we also have an additional protection for juveniles, which was the bill that was passed last session, outlining the juvenile Miranda rights. So that's what we have in Nevada. I want to kind of backtrack and thank Assemblywoman Gonzalez for working with us and the Innocence Project to try to reach consensus on this bill. We've had respectful dialogue and a useful exchange of ideas and policy positions for all the stakeholders. We're not able to reach consensus yet, and we do have some lingering concerns that are reflected in the amendment that is on Nellis. I want to go through what our amendment does, which is a couple of pretty straightforward things. First, it changes subsection 3 to add a peace officer or other person who's conducting a custodial interrogation. It is not necessarily going to be suppressed, right? If they make a representation that is not true to the juvenile in order to obtain information necessary to timely investigate a homicide or attempted homicide. Now, I don't just sit before you today as a prosecutor. I sit before you as a mom to 2 boys who make poor decisions sometimes, and I want their rights to be protected. That's something I want to balance with the fact that our children are in dangerous situations at school, and sometimes we can't protect them from threats that come from without, and sometimes they are from within. And so in consideration of that, we did build a homicide or attempted homicide exception in. And that's what subsection 3A1 and 2 does, and then there's corresponding language in section 3B. The second thing that the amendment does is try to address one of the concerns that Mr. Pirro raised during our many discussions on this bill, and that is his fear that if this was not added into chapter 171, which is a huge chapter, it's got a lot of stuff in it, proceedings to commitment, statutes of limitations, warrants, custodial interrogations, a lot of other things. We wanted to move it into Chapter 62C, because in Chapter 62C is where we have our juvenile Miranda rights. So that makes sense to us from an organizational perspective, but also to make clear in subsection 5 of our amendment that nothing about moving that would operate to deprive a juvenile of those rights if they are later certified as an adult pursuant to NRS Chapter 62B, which is the adult certification process for certain offenses. And with that, I would be happy to answer any other questions the committee might have.
Any other questions from members of Senator Stone?
Thank you, and forgive the ignorance not being an attorney. Can you differentiate a juvenile Miranda right from an adult Miranda right?
Jennifer Noble for the record. Thank you for the question, Senator Stone. So last session, I believe, AB 132 was passed. And you're probably aware, Senator, of the standard Miranda rights here on Law and Order. So I'll just read them briefly to you so you can see the difference. NRS 62C.013 says that a peace officer or probation officer who takes a child into custody pursuant to NRS 62C.010 shall, before initiating custodial interrogation, give these rights. You have the right to remain silent, which means you do not have to say anything to me unless you want to. It is your choice. If you choose to talk to me, whatever you tell me, I can tell a judge in court. You have the right to have your parent or guardian with you while you talk to me. You have the right to have a lawyer with you while you talk to me. If your family can't or won't pay for a lawyer, you will get a free lawyer. That lawyer is your lawyer and can help you decide that you want to talk to me. These are your rights. Do you understand what I have told you? Do you want to talk to me? So you can see the language is adjusted for younger people.
Thank you. I appreciate that it's brought down so a child can try to understand what they're faced against. But so, in your testimony, are you saying that you can use these tactics that they're trying to say are inadmissible to court in cases of murder? Is that one of the exceptions you're talking about, that if you need to deceive someone to get the truth out of them to solve a murder, that you believe that it's necessary to use that tool?
Jennifer Noble for the record. We're trying to craft something that's flexible. So then in the event that we've had a homicide involving juveniles or an attempted homicide, and we believe there may be danger that continues to present, that if necessary, certain representations could be made. But again, the court's going to look at the totality of the circumstances and decide whether or not any statements were voluntary. I also just have one comment I'd like to add briefly. So, Mr. Erb from the Innocence Project is a very interesting person to talk to, and I have a lot of respect for him. And we've talked about wrongful convictions. And what was referenced are wrongful convictions in Nevada, and I think there were 4 that were referenced. But I would just ask you to consider that in 2 of the most famous wrongful conviction cases in Nevada, which involved adults, again, no known cases involving juveniles, DeMarlo Berry, that was because of a jailhouse informant's testimony that was later rescinded. That was a major factor in that false confession. And we were cooperative and are working with the Innocence Project on legislation to help alleviate those types of jailhouse informant confessions that can contribute to wrongful confessions. And second, with Kathy Woods, that was a confession initiated by Ms. Woods in a mental facility outside Nevada that was initiated by Ms. Woods, and the original people interviewing her weren't even from Nevada. It was a long time ago. So when we're talking about what contributes to wrongful convictions, that is definitely a concern, but I'm not sure that a nexus has been demonstrated between the ability to, at times, make certain representations to juveniles that are not correct in the context of an interview. But it is clear under Nevada law that they're generally disfavored. The court's going to look at them under the totality of the circumstances, and there's no clear and dry answer to whether or not deception can be used with respect to juveniles.
Thank you.
Other questions? Vice Chair Harris.
Thank you, Chair. So, Ms. Noble, I think you answered the first part of Senator Krasner's question, and that is it legal? The second piece was, what is the rationale? Could you give us a bit of the NDAA's justification for the rationale for allowing a trained cop adult to lie to a child who has been taught to trust police?
Jennifer Noble for the record. I want to start by one of the assumptions in your question, Senator, and that is that the child's been taught to trust the police. That's not always the case.
Skip that assumption, then the question still stands. What's the rationale for allowing adults to lie to children, to elicit confessions that they think are the actual truth? What's the rationale for allowing this practice to exist?
Jennifer Noble for the record. The rationale in terms of our amendment, which crafts language that goes beyond Bessie and definitely beyond the United States Supreme Court's precedent, is that there are situations in which, in order to protect, and in my mind, specifically other kids, we have to get information quickly. So it's sort of, I could see you were going to say something.
Through deception? Is that the argument you're making? The only way to get truthful information out of juveniles is to deceive at times?
Jennifer Noble for the record. I think one of the primary problems is that we're using the word deception, but what came up and what was clear during our discussions about this bill, and we had a lot of discussions, is that we couldn't agree on what that meant. So in other words, does deception mean if you take my 8-year-old in and you say, I really like Paw Patrol, and you try to build a rapport, and you've never watched Paw Patrol, is that deception? If you say, is there any reason your fingerprints might be on the gun, is that deception?
Let's define it as making a materially false statement about evidence that is reasonably likely to elicit an incriminating response from the child. It's from the bill.
Okay. Jennifer Noble, for the record, my answer to your question, Senator, is that there may be circumstances in which there is an exigent, a concern, an emergency in which we were trying to get information quickly and we needed to protect other people.
And is the logic that follows then that the only way to get that information was to lie to a juvenile?
Jennifer Noble, for the record, it's going to depend on the situation, Senator. I can't answer that definitively. It's going to depend on the facts and circumstances, the evidence that the officers have, and other than that, I can't give you a better answer. I'm sorry.
Are you familiar with the Reed technique?
I am somewhat, Jennifer Noble for the record, yes, I am somewhat familiar with the Reed technique, although as you're aware, I am not someone who conducts custodial interrogations.
Are you familiar with any of the studies suggesting that the Reed technique sucks?
Jennifer Noble, for the record, I have read some studies, or I'd say glossed over studies regarding the Reed technique, and that there are definitely people in the law enforcement community who believe it is not the best method. Yes.
Did those studies give you any pause at all about applying that technique or relying on confessions or any evidence that comes out of a custodial interrogation where that technique is used heavily?
Jennifer Noble, for the record, those studies did not give me pause when I am looking at a bill with the current language that operates to create provisions that are inconsistent with the United States Supreme Court and inconsistent with the voluntariness and totality of the circumstances approach that the Nevada Supreme Court uses when it comes to deception. So I guess, no, I had no pause in that context.
Why would this be inconsistent with the Supreme Court's decisions? I consider the Supreme Court a floor, and even if the Supreme Court says you lie, there's nothing that you can lie. There's nothing that says that the state of Nevada can decide to say, no, you can't lie and provide additional protections for juveniles. That's not necessarily inconsistent, is it?
Jennifer Noble, for the record, it would be different. I mean, this body could pass a law that says you can't interview juveniles ever, and you can't interview anyone in custody ever. That would arguably be inconsistent with Nevada Supreme Court authority. So I'm going to disagree with you.
That's the first time that's ever happened. Actually, I think it's even a lie I think it's don't we have a criminal penalty for lying to legislators from that table? All right, anyway.
Jennifer Noble, for the record, I want to be clear. Senator Harris, are you stating that I'm lying to you? Okay.
No, not at all. I was drawing a connection between us not allowing lies in certain places, but now making arguments that they are necessary in others. But anyway. Okay, last question. England, Australia, New Zealand, Germany, all prohibit lying during police interrogations. Are you not confident that we could keep people safe if we don't prohibit lying to juveniles like these other countries do?
Jennifer Noble, for the record, in answering your question, I haven't looked at the laws of those specific countries. I know I'm not allowed to ask you questions, but I don't know if those countries, if there is something that's considered a lie, and again, what is considered deception, what is considered rapport building, I don't know those specifics. And if that occurs under every circumstances, every aspect of the statement suppressed. I don't know the answer to that question. And then secondly, no, I'm not confident that we could keep people safe if we're prohibited in every circumstance from using deception, no matter what's going on. No, I am not.
Okay. No more questions. Thanks. Just disappointment.
I'm sorry you're disappointed in me, Senator Jennifer Noble. For the record, I do want to again emphasize that Assemblywoman Gonzalez has engaged in probably hours at this point of working with us, working with the Innocence Project, and working with law enforcement, and that we do appreciate her hearing us out on this bill. And I thank you for your time. I know this is a contentious hearing today.
Thank you. Wait, I think we still have some more questions for you. It was just Senator Harris who was done. But
Jennifer Noble, for the record, could I take those questions from underneath the dais, underneath the table?
You can phone a friend if anybody else wants to come up here and help out, Ms. Noble. Although I think you're doing an excellent job, and I appreciate I appreciate you being here, and I appreciate you engaging in this discussion with us. I will allow Senator Orenshaw to ask a question, or as many questions as you'd like.
Thank you, and I'll try to keep it brief. Thank you for your testimony about the amendment. Certainly, you know, the language about protect life or property from imminent threat, that seems really reasonable, that I could see that might be necessary. in the new language about to obtain information, the new suggested language, to obtain information necessary to timely investigate a homicide or attempted homicide, that one concerns me, and I'm also a little concerned about how expansive it might be. Like, let's say there's a child in custody, and the questioning gets to a homicide or attempted homicide at a party 2 weeks ago, and the law enforcement officer is interested in information. And maybe this child's not a suspect, but the law enforcement officer says, we have you on video at that party. Tell me who you saw shoot the gun. So do you see this as being so expansive that it would cover attempted homicides that the child's not actually a suspect on, but that maybe law enforcement wants to get more information about? Because I don't see it being limited to an allegation of a homicide or attempted homicide that child's a suspect on. So I'm a little worried this could be something maybe the child's friends or family that you're trying to get information on, and false statements could be used to elicit information that maybe the child will think is helpful to them getting out of this situation they're in now, especially if there's, a law enforcement officer in uniform with badge and gun and they're scared and want to go home.
Jennifer Noble for the record. So, Senator Orenshaw, I think that what you're talking about is an investigation that sounds like it's pretty after the fact. This isn't, and when we crafted that language, it put timely in there, trying to capture that there's like sort of an urgency. So if that's something where we need to work on formulating that language to narrow it down with respect to homicide and attempted homicide, I think you've raised a valid concern there, and we can certainly work on that.
All right, thank you. Thank you, Chair.
Thank you. Senator Wynn.
Senator Orenshaw kind of addressed the first issue. If I can have a couple of questions, if that's fine, Chair. I specifically read that as well to include child witnesses. And we're getting into this scenario where I imagine, under 18, you have a 10-year-old that you're talking about some grisly murder that they might have just been a witness to. And now you're lying to them about something that's terrible. And again, we're lying to children, which I don't know, I have issues with anyway. But, and just with your amendment, I guess I'm looking at this and it seems like this amendment just carves out these limited circumstances for murder and attempt murder. And I guess my biggest concern is if this is a policy that we want to move forward with, it shouldn't matter if it's a petty larceny or a murder case. If it is a bad policy and it is a bad practice, I don't know why we would want to make an exception in what are some of the most highest stakes cases. And I think one of the people that testified, the district attorney in California, said it best. I don't think you as a district attorney would want to have to go back and redo some of these more serious cases because you're desperately holding on to this one exception that is, if it's bad for these children under these circumstances, and it sounds like this is bad for adults as well, and then add on the children aspect of it. So I'm just wondering, what your response is to that idea of not wanting, you have cases on appeal all the time, and the worst thing probably is to have to go back and redo something that re-victimize victims, put people back through this process, put someone in custody or incarcerate them, wrongly based on this bad practice. So I guess kind of a statement question.
Jennifer Noble for the record, and I understand the points that you're making, and I appreciate your concern, Senator Wynn. I think it's important to know, though, that when we're talking about this exception that's in the current amendment, the courts still have to, under the U.S. Supreme Court precedent, Nevada Supreme Court precedent, evaluate the use of deception when they're considering all those factors that inform voluntariness. So it's not just any time we can use deception, and that means it was voluntary if it was a homicide. It's still going to be a factor among the other factors that I listed earlier in my testimony, and as you know, as a criminal law attorney, that's not an exhaustive list. So deception is still a factor that the courts will consider, and we can't legislate away that because obviously the Supreme Court's the supreme law of the land. So
Well, and just to follow up on that, in Senator Harris kind of, and we obviously it sounds like we're going to disagree. It's my understanding that the Supreme Court of the land interprets the laws that the legislative body and the legislative branch of government institutes. So right now, the state of the law is what you have done, and that's what's guiding your practice. But if we change the law, then it's up to the Nevada Supreme Court to interpret that if it's unconstitutional, I guess. So I agree, and I probably disagree with you on how the legislative branches work in conjunction with the judicial branches. But with that being said, and this might be a question for law enforcement, I see a bunch of them in here. I've had the opportunity to look at this HIG report, and it seems like moving away from this is best practices. And I'm looking at them because I honestly don't know where they stand on this. I'm assuming that they practice in our state the best practices, and they don't use Supreme Court precedent or case law precedent as their floor, and that they're always trying to strive for whatever the best evidence-based, whatever the best modern practices are in their law enforcement practices. So even though you had mentioned that it's disfavored to lie to children, it sounds like all the evidence that is in a part of these extensive reports says that it's beyond just disfavored. It's not actually accurate and effective, and doesn't. So I guess that may be a question for law enforcement if they come up and testify in whatever position they are, to address whether or not they use best practices, and if these are the best practices that they use. Because I know you're only interpreting what is taking place in there, so it's not really a question for you. So I probably could have saved that for someone else. But if you have any thoughts on that, that would be wonderful to know, whether or not you are always looking for your law enforcement partners in this prosecutorial role that you have to use the best practices when it comes to interrogation and investigation.
Jennifer Noble, for the record, I want to clarify something that I said earlier. What I was trying to communicate is that even if I was advocating for policy that said it is always okay to use deception with children, or sometimes okay, I could not, or this body could not, change the fact that the United States Supreme Court says, no, we're going to consider that when we consider the voluntariness of the statement. I just want to clarify that, because that would not be something I would say as an appellate attorney, and maybe that is what I've said. I've been up here a while. Second, I'm not an expert on interrogation techniques, but I can tell you, whenever I look at records, whenever I look at tapes, whenever I work in a habeas context or a petition for factual innocence, I'm always looking at the interview to see if the totality of the circumstances, even if a court's found differently, indicates that the subject's will has been overborne, or that the information is not reliable. So that's a concern that I have as a prosecutor. I can't speak for the techniques or the philosophies of all our law enforcement partners up here today, and it would be really bad if I tried to do that.
Any other questions? Senator Krasner.
Thank you, Chair. Thank you, Ms. Noble. So I'm looking at the amendment on the back, Section 3, Sub 2B. The questions asked by the peace officer or other person were limited to those reasonably necessary to obtain information related to the imminent threat, homicide, or attempted homicide. So would a law enforcement officer be able to say, well, we were so worried about this imminent threat of homicide or attempted homicide that we made this statement to a child: we have your DNA, son. The law is such that if you are caught lying to us, your mom goes to prison. I'm serious. Is that a statement that could be made?
Jennifer Noble, for the record, I'm trying to make sure I understand your question, Senator Krasner, respectfully.
Yeah, of course. My question is, could a law enforcement officer basically just tell a blatant lie? I mean, young man or young woman, do you know the law? No, sir. Well, the law is such that if you're caught lying to us because you're a kid, your mom is the one that will go to prison. Could they make that statement? I'm concerned about the psychological effect on a child, so I'm just wondering, could that blatant of a lie be said to a child?
Jennifer Noble, for the record, respectfully, the authorship of that question is confusing to me, but I will try to answer it the best that I can.
It's my question.
No, I'm just saying the way that it's written. I don't quite get it still. But it would need to be reasonably necessary to obtain information, right? So is it reasonably necessary that we're gonna put your mom in jail? Probably not, and they'd have to explain to a court why it would be reasonably necessary.
And then could the law enforcement officer say, well, we were so worried about an imminent threat of homicide, we had to do something immediately. We were so concerned, and we know the kid doesn't know the law, so we just lied to him because it's legal.
Jennifer Noble, for the record, the law enforcement officer could say anything, but they're going to have to say it to a judge under oath in a courtroom, and it's up to a judge to decide whether or not they're going to buy that.
Thank you very much.
Vice Chair Harris is going to follow up really quick.
Very quickly, I promise. So I think you just said to Senator Krasner that the lie has to be reasonable to obtain the information. But the way I read this amendment is that you have to reasonably believe the information sought was necessary to obtain information necessary to timely investigate or homicide. And so regardless of how out of line the lie may have been, your mom's going to go to jail. As long as the officer felt that the information sought was necessary, they'd be allowed to do it. That's how I'm reading the amendment that you put forward.
Jennifer Noble, for the record, I would note that reasonably necessary language is not just from our amendment, right? But we have the reasonably necessary to obtain information related to an imminent threat, and then we've added homicide or attempted homicide. But nevertheless, I think you still have to demonstrate that it's reasonably necessary.
The information sought has to be reasonably necessary, not the lie, right?
Jennifer Noble, for the record, no. The questions asked have to be reasonably necessary. That's my interpretation of it.
I'm tagging in legal counsel.
Carly Okrent for the record. As this is written currently, the language that we're discussing is an exception to the prohibition contained in subsection 1. And so to the extent that we're talking about whether or not the question or the information that's being sought is something that they can lie to a child about, it basically is the circumstance in which subsection, I'm sorry, let me backtrack just a second. It's an exception to subsection 1, and as a result, it's not the line of questioning, but rather the information being sought.
Okay, thank you. Senator Hansen.
Thanks. I guess a very interesting discussion. Again, question, in Nevada, are you aware, maybe somebody else can answer as well, of any convictions involving underage, under 18 people that have been convicted that they actually had their convictions reversed because of false confessions?
Jennifer Noble, for the record. Senator Hansen, no, I am not. And during our discussions, nor was any member of the Innocence Project or the El Dorado District Attorney who testified previously. We asked that question several times.
Okay, well, no, that's kind of what I'm getting at. Are we trying to solve a problem that doesn't exist is kind of what I'm getting at. So anyway, it's very difficult, though, to try to defend lying, right? So I don't like that either, but I do want to know if there is a problem with our law enforcement community abusing such unusual practices. Yeah, maybe we do need to crack down, but if that was the case, I would certainly expect there to have been at least a dozen reversals of convictions based on confessions that were brought about through apparently deliberate lying. But the answer is no, apparently. If anybody's got a different answer, I'd love to hear it. Thank you, Madam Chair.
Thank you. Back to Senator Wynn.
Sorry. And I just want to clarify, when we're talking about juvenile convictions, they don't have actual convictions that would have overturned. They have like adjudications. Isn't that correct?
Jennifer Noble, for the record, that is correct, but we do, of course, have cases in which the juvenile is certified up. So that may be part of why that hasn't been identified. I don't know, but I am not aware of any such case.
And we also have a system where like over 90% of cases are resolved by way of plea negotiations. So we aren't having a situation where a lot of people are going to trial and then later having their convictions overturned.
Jennifer Noble, for the record, I mean, when we're talking about juveniles, probably not. I can tell you with regard to adults, whether or not they plead, they file all sorts of stuff, and it's my day job to look through that stuff and see whether or not they have reasonable grounds to assert that their conviction was wrongful, and that happens whether or not they plead.
And then I guess my other question is again, the way I read this is it potentially could be child witnesses that are interrogated through this lying and this deception, and there could be a situation where you're investigating a murder of an adult and the child is not a suspect, and so you're basing perhaps faulty confessions or evidence from like this deceptive, this lying to children in order to convict like an adult in that situation. I mean, is that my understanding? If you're allowed to use these deceptive interrogation tactics with child witnesses?
Jennifer Noble, for the record, my belief is that the intent of this bill and our intent in crafting the amendment that everyone's so crazy about today, and I mean love so much, is that we're talking about suspects in a custodial interrogation setting that are under the age of 18.
Okay. And I hate to reiterate it, but if this is a good policy, which I think it is intellectually inconsistent to have an exception for certain crimes. And I have a hard time understanding why we would make an exception if lying to children is bad and produces potentially bad outcomes.
Jennifer Noble, for the record, I'll just say one of the most challenging parts of my testimony today is that, when you're trying to discuss something and solve a problem, you all have to agree on the nomenclature that you're using, right? And so we're using the words lying, we're using the words deception, but I'm not sure that we're all on the same page about what those are, and you could probably ask every single person sitting up there to be different.
Thank you. Are there other questions? I have kind of a question, but more of a comment, because I just want to make sure that all of us on the dais, but really all of us in the room, are operating under the same understanding of how this would function in practice. And so I know how much we all love hypotheticals. So I'm going to try not to get too wild with it, though, and I do want to check my own understanding, because this is a constitutional question. We're talking about putting some guidelines into statute on how we evaluate a constitutional question. So if you, Jenny, are prosecuting my client who is 16 years old for a murder and you indict him, so it goes through grand jury, I'm his defense attorney, I'm not there. When it comes to district court, first thing I'm going to do is file a writ of habeas corpus to try to get the charges thrown out. One of the things I might argue would be, hey, when Jenny went to the grand jury, she put the detective on the stand and built her case around the fact that my client admitted to handling the gun, he was caught on video leaving the scene, and whatever else, and he had texted the victim earlier that day. Those might be like your pieces of evidence, including that my client admitted to handling the gun. Am I losing you?
I'm sorry. Could you just say that? So your client, we're at grand jury.
Yeah.
You file post grand jury indictment, Senator Jennifer Noble, for the record. You file a pretrial petition for writ of habeas corpus, indicating that during the grand jury proceeding, we relied on statements that your client made, admissions.
Exactly. And now I want to argue that those admissions were involuntary, and so they should be thrown out. And so I'm going to argue to the judge that, I want to avail my client of this remedy. my client's admissions were involuntary, therefore they should be thrown out and the whole case should be thrown out. And there are all kinds of reasons that we can argue that someone's statement was involuntary. With this bill, we're adding a reason to that list. My client is a minor, and a peace officer knowingly made a material false statement about evidence that is reasonably likely to elicit an incriminating response from the child. So the first thing that we're going to do in my habeas petition hearing is ask the judge to rule on whether or not the officer who was investigating my client actually made a material misrepresentation. So if what the officer did was say, hey, we have you on video with the gun, and the video doesn't really show the gun, it just shows the client, that would be the first argument that we would have in court. And we would fight about whether or not that is a material misrepresentation. And let's say that the court rules in my favor, and they say, well, Melanie's right, that was a material misrepresentation. We go to part 2, that's presumptively involuntary. If we don't accept the amendment to the bill, we stop there. That statement is involuntary, has to be thrown out, I win. If we accept the amendment to the bill, there is a second inquiry, which is, well, does it fall under the imminent need exception? And then we would have another fight in front of the judge where you say, well, the cops had to talk to Melanie's client that day. They were looking for the weapon. By telling him they'd seen him on camera with the weapon, it increased their likelihood of actually finding it. It was necessary to deceive him in order to investigate a homicide that had just happened. And I would come up with whatever my argument is. It wasn't necessary. It wasn't timely. It didn't lead you to the weapon anyway. The weapon's still never been found. And then the judge would make a ruling. And so the difference between the bill as written and the bill with the amendment is that second part of the argument in front of a judge, whether or not this instance happened to fall into that very narrow exception of a murder case, and the prosecutor would still have to show that it was necessary to obtain information, and there would still be the opportunity for the defendant, through their counsel hopefully, to argue that it actually wasn't necessary and possibly get the statement thrown out anyway. Is that the difference between the bill as written and as amended?
Jennifer Noble for the record. Chair Scheibel, that is correct. I think you've crystallized that pretty well in your example.
Thank you. Any other questions? All right, I really, really appreciate you walking us through all of that. We will move to testimony now. And what I'm going to do on testimony in support of AB 193 is take testimony at the same time, whether you're in support with the amendment or without the amendment or only with the amendment. Just tell us when you testify that you're in support only with the amendment, or you're in support either way. Or I guess you could be in support only without the amendment. In which case, tell me that. Let's start with testimony in support of AB 193 in person in Carson City.
Jennifer Noble for the record. Just in case it's not clear, the Nevada District Attorneys Association is in support of the bill with the amendment.
Good afternoon, Chair. John Puro for the record from the Clark County Public Defender's Office. There's a couple things that were discussed. We are in support of the bill without the amendment. If the amendment were to be added, we would oppose this bill and we would ask this committee to kill the bill. Voluntary is always a weird question. Little kids are brought into rooms no bigger than this table, padlocked to the table. Sometimes when they come in and they're not handcuffed, they're like, well, you're free to leave. But when you're in there with an adult with a badge and a gun and you think you need to be there, you really don't feel like you're free to leave. And it doesn't really feel voluntary. And most adults don't necessarily feel like they're free to leave. There's a power imbalance between children and adults. Another thing that we talked about is, Senator Hansen, you said our juvenile cases, has this happened? Well, most murder and sex cases are the ones that get the most attention, and that's where the ones are overturned the most. Juvenile cases, though, because the system is different and we look to rehabilitate the child, they very rarely get appealed. So if there's a problem it very rarely sees the light of day, especially in juvenile proceedings. And sometimes our plea agreements are of such a nature that if you accept the plea agreement because you don't want to accept the risks, you agree to waive your appeals. And I wish they weren't that way, but that's kind of a commitment that was made a long time before I became a public defender. Every cop I know, and I talk to personally, tells their kid to ask for a lawyer when they get interrogated. And every DA I know tells their kid the same thing. But sometimes, for some reason, we're like, it just doesn't apply to the rest of the public, and I don't understand that. We talked about Kathy Woods, the adult case, right? Police thought that confession was okay, even though they were interviewing a woman at a mental health hospital. And then the court didn't do anything about it, and my colleague from the north, Ms. Pusich, had to fight that case for decades and decades and decades until Kathy Woods was released. So courts are definitely behind on the science, and that's why I think the Innocence Project is bringing the science here forward. And I think this is an important bill without the amendment. One of the reasons I became a public defender was in my undergrad, I saw this documentary, Murder on a Sunday Morning. I believe the full documentary is on YouTube, and it's not like you have a lot of time to view it, but there were two public defenders, and there was a juvenile that was coerced in Florida into a false confession in a murder case, where the most pressure happens to children. Murder cases, sex offense cases, because those are high profile and police want to find the suspect. And sometimes not everything's done correctly. And I don't mean to impugn the integrity of the officers here today, but sometimes things happen. And this is a protection that should be put in place. I highly recommend you watch Murder on a Sunday Morning to watch what could happen to a child when placed in that power imbalance situation and what could happen and the legal hoops you have to jump through as a defense attorney to try to protect that child. If this amendment were to be accepted in any shape or form, I'd ask this committee to kill the bill. I would urge the committee to pass it without amendment. Thank you.
Good afternoon, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office, testifying in support without the amendment. I echo the sentiments of my colleague from the South. What I want to add is a story from up here in Reno, where the Washoe County Sheriff's Office, actually, I take that back, it might have been Reno Police Department, but it was a murder case, Anita Rohr, which was overturned on appeal this past year. The facts of this case are more than troubling. Ms. Rohr was developmentally disabled, an adult, but a vulnerable adult. She had been the victim of sexual and domestic violence her entire life. She had limited schooling in her life and was living unhoused by the railroad tracks in Reno. She was accused of murdering another unhoused person where there was no DNA evidence, no witnesses. All there was a confession that was taken from Ms. Rohr after an initial 9-hour interrogation where she maintained her innocence, and then another 5-hour interrogation where she maintained her innocence. During that time, officers provided falsehoods to Ms. Rohr, including that the entire incident was on camera, that her DNA evidence was on the victim's body and the victim's DNA was on her body, that the victim's hair was found in her hands, and that her co-defendant had had sex with the dead body that was found. None of this was true. And after those lies were fed to her, and after an initial 9-hour interrogation and then a subsequent 5-hour interrogation, she made a false confession. That case has been overturned on appeal. She is still in custody. She is going to go back to trial. So these things matter. And I'm going to be frank. I can hear whispering behind me. I think that the Washoe County DA and I are going to disagree, quite frankly, on how horrendous the facts of that case are. But the case file speaks for itself. And these lies happen. And I personally have more faith in police officers. I believe they are capable of doing their jobs. I know the police officer sitting next to me is capable of proving a murder and solving a murder and keeping this community safe without making those lies. And we should not be lying to vulnerable people. We should not be lying to anybody. And we especially should not be lying to our children. Thank you.
Chair Scheibel and the Senate Committee on Judiciary. First, I'd like to thank the kind comments of Ms. Roth. Also, I'd like to thank Assemblywoman Gonzalez and Mr. Erb from the Innocence Project. We've had many conversations about this issue. We are in support of the amended version of AB 193. We share many of the concerns with Ms. Noble. We believe that the amendment is the best version of the bill that we can get. Just to be clear, though, that we are unaware of any of our interrogation tactics being an issue in Nevada. Also, to be clear, that a confession is only one part of an investigation. There are several different things that we look at, many different techniques that we use to interrogate people, and still it needs to be voluntary and uncoerced. We feel that this bill does that. Thank you.
Hello, Chair, members of the committee. My name is Lilith Barron, Lilithbaran, with the ACLU of Nevada. I think that my colleagues from the public defenders, both North and South, have made the point that I would like to make as well with wonderful evidence. We support this bill without the amendment. We absolutely do not support the amendment. Thank you.
Good afternoon, Chair Scheibel, members of the committee. Greg Herrera for the record, Herrera, representing the Nevada Sheriffs and Chiefs Association. We are in support of AB 193 with the amendment as proposed by the Nevada District Attorneys Association, and we'd like to also thank Assemblywoman Gonzalez for including us in these discussions. Thank you.
Good afternoon, Chair Scheibel, members of the committee. Jason Walker, Wash County Sheriff's Office, testifying in support with the amendment on AB 193. The goal of any juvenile interrogation should always be to obtain voluntary, truthful statements corroborated by evidence and case facts. Again, testifying in support with the amendment.
Thank you. I don't see anybody else coming up to give support testimony in Las Vegas or in Carson City, so we will go to the phones for support testimony on AB 193.
To testify in support of Assembly Bill 193, please press *9 now to take your place in the queue.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Quentin Savoy. That is Quentin. Last name S like Sam, A like Apple, V like Victor, WOIR. I'm the president of the Las Vegas NAACP, and we are firmly in support of our public defenders with AB 193 without the amendment. Thank you so much.
Good afternoon, Vice Chair Harris, committee members. My name is Deshaun Jackson, DASHUN. I serve as the Safety and Welfare Policy Director with the Children's Advocacy Alliance. The Children's Advocacy Alliance stands in support of AB 193 without the amendments. We believe in protecting the rights of children and giving them a fair chance. It's important that we stop deception during juvenile interrogations. It's time for Nevada to take a stand and protect the rights of our young children. As mentioned, the data has demonstrated the negative impacts that lying during an interrogation has on the lives of our children. It's crucial that we protect the overall process and maintain the integrity of interrogations. The Children's Advocacy Alliance thanks Chair Scheibel for this very important bill. And again, we support AB 193 without the amendments. Thank you.
Hello, my name is Katie Banuelos, that's Banuelos, and I'm speaking on behalf of the Libertarian Party of Nevada. We are strongly in support of this bill without the amendment. It's a matter of basic integrity. Police officers should be held to the highest standards of conduct, and there's just no situation in which it's acceptable to lie or deceive a child. Furthermore, they shouldn't be lying or deceiving anyone. We'd encourage lawmakers to extend these protections to all people, not just to minors, but it's especially important when it comes to minors. Presumption of innocence is the most basic foundation of the justice system, or should be, and we strongly support this bill. Thank you.
Hello, my name is Jagada Chambers. I'm actually a constituent of the Honorable Chair, and I'm a Clark County School District father. I want to strongly urge the Judicial Committee to support this piece of legislation without the amendment. We want to eliminate this practice, and I think what substantiates the need for it is the gulf of the two realities of how plentiful me as a person who's impacted in our community, who is leading work that engages these families. I feel like the practice is plentiful and readily, especially here in Clark County. And then so for so much of our law enforcement to feel that it's probably a practice that they could never see using unless under murder, that seems to be disingenuous, and we know it's plentiful here, and urge this committee to get this through so it can get voted upon. Thank you so much.
Caller, can you please spell your name for the record?
My name is Jagada, Jagada, last name Chambers, Chambers.
Thank you. Caller, you are unmuted and may begin. Caller with the last three digits, 963. You are unmuted on our end. Is there something on your...
Hello. Oh, yeah. Sorry, I'm here. Can you hear me now?
Yes, go ahead.
Okay. Hello, my name is Yesenia Moya, Yesenia I am calling today in support of this bill without the amendment. I am completely in disagreement with the amendment and the folks that have come up and talked about that amendment in particular, because the truth is, as a community member and as somebody who has family that's been incarcerated and prisons and friends and other folks in my community that have been taken away, I know for a fact the police lie, and they do so in various different ways. For example, my very good friend, when he ended up getting directly filed, he was told in his initial interrogation, which was 8 hours, that they could give him probation if he confessed, if he said this, if he said that. And that comes straight from the folks that are going through this. And as somebody who has grown up in this community, I've seen how lies are done by police, as I've been lied to by themselves as well. So please, please pass this bill, as there is no room for any kind of deception, regardless of what meaning it brings to you personally, in our justice system. Thank you.
If you've recently joined the call and would like to testify in support of Assembly Bill 193, please press *9 now to take your place in the queue. Caller with the last three digits, 611, please press *6 to unmute.
Hi, my name is Jessica Orta, O-R-T-A, for the record, and I want to speak in support of AB 193 without the amendment. I'd like to remind you that we're supposed to be able to trust these police officers, not that I do, but when they have legislation that backs them in using deceit, especially with our children, it doesn't increase the amount of public trust for me. Not only that, I heard somebody say that this bill is, the amendment was made with good intentions, but I'd like to remind you all that the road to hell is paved with good intentions, and that we don't always make it to the destination. So you guys need to really think about the language that you're using, and your intention does not necessarily reflect the way that it is practically used or applied in public when you allow the police officers this level of freedom. So once again, please pass AB 193 without the amendment. Thank you.
Caller, you are unmuted and may begin.
Hello, my name is Leslie Turner, Leslie Turner, and I'm calling in support of SB 193 without the amendment. And I mean, I think I can keep it brief. Pretty much everyone's already said what needed to be said. We shouldn't be setting a precedent for police officers to be able to lie to the community, whether it's youth, whether it's children or adults. The burden of supposedly uplifting truth, uplifting the justice system, and uplifting integrity, that burden lies on everybody. But, those folks are police officers, law enforcement, the DA, like they're actually being paid to do that. So, again, we shouldn't be setting a precedent saying that it's ever okay for law enforcement to lie to children at any point in time, and also not the broader public, but this bill in particular is about youth. So I stand in support of SB 193 without the amendment, and thank you all for hearing this bill.
Chair, there are no more callers to testify in support.
All right, we will move to testimony in opposition to AB 193. I don't see anybody coming up to the table in Carson City or Las Vegas, so we'll go to the phones for testimony in opposition to AB 193.
Thank you, Chair. If you would like to provide testimony in opposition to AB 193, please press star 9 now to take your place in the queue. There are no callers wishing to offer opposition testimony at this time.
All right, then we'll go to neutral testimony. Anybody wishing to testify in neutral in person is invited to do so now, but I don't see anybody coming forward, so we'll go to the phones for neutral testimony.
If you would like to offer neutral testimony to AB 193, please press star 9 now to take your place in the queue. There are no callers wishing to offer neutral testimony at this time.
All right, then I'll turn it back over to our presenters for closing comments. All right, sounds like Mr. Erb is going to make closing comments.
Thank you, Chair. For the record, Nathaniel Erb here on behalf of the Innocence Project. I want to thank the committee for its great discussion and investigation of this issue. I also want to continue to thank the District Attorney Association, particularly Ms. Noble, and law enforcement throughout Nevada who have worked with us on this and many other issues. And even though we don't always find a place of agreement, it's always respectful, and I appreciate all of their input in this. I do want to provide some responses to questions that were asked. I do want to concur that the Supreme Court does set a floor in these issues. The Supreme Court cases, as my colleague, Ms. Pearson, pointed to, dates back to the early 60s and has been reaffirmed in different cases. It is not an assessment that deceptive interrogation is a necessary or viable interrogation tactic, but that simply the due process clause alone does not rule out deception per se. It says this in the case that deception in some circumstances may not render a confession involuntary. But it has also affirmatively said in many scenarios that the court has extreme disfavor of the use of these tactics, and explicitly that it is the responsibility of state legislatures to adopt rules regarding the admission of evidence to assess whether a confession is still reliable if deception is used. And that's what this bill would adopt. I also wanted to, if I can, make a slight addendum to the chair's great assessment of the process throughout the bill. After the first step of the defense first having to prove that a lie even occurred, that the lie was made knowingly, that the lie was material, and that the lie was reasonably likely to elicit an incriminating response. That does create a presumption of inadmissibility, but it is just a presumption of inadmissibility. It is not automatically excluded at that point. The state then only has to demonstrate by preponderance of the evidence, which is the current standard, that it is voluntary, and the only addition to this bill is that it's reliable and that the lie didn't cause that person to say what they said. It didn't induce them to do so. So this would it would still allow lies in the case that law enforcement really feels is necessary. But what we're asking through this bill is if you're going to lie, if you're going to go against what is taught best practice, that you do so in a way that you feel comfortable you're going to be able to prove that it happened. You could be doing that through identifying, oh, here's all the evidence that clearly led us to identify this as the right suspect. Here's how all the statement made by the suspect came from them, and it wasn't provided by law enforcement providing all the details. It's just raising the bar ever so slightly by saying that the confession shouldn't just be voluntary, but that we can believe the veracity of that confession in the same way that we provide a heightened standard for forensic evidence or for witnesses or for other types of evidence. It's just raising that bar just a little bit. Whereas other states have raised that to clear and convincing evidence, or states like Utah and Indiana have ruled it out entirely. This just creates a slightly higher step. I appreciate the amendment that was suggested. However, the reason we don't support it as currently drafted is the bill, as was brought over from the Assembly, already includes an exception to all of this for imminent threats to property or imminent threats to life. So if there is a provable imminent threat to someone's life through a threat of homicide or attempted homicide or anything that could cause someone bodily harm, that would already be exempted under the bill. The way I read the amendment is it's not about an imminent threat. It's just about any homicide or any attempted homicide that could occur. This could be a cold case that there's no actual threat to anyone currently that's provable, and we just want to be able to lie in that circumstance. And from the Innocence Project perspective, those are the cases we are most concerned with. As I mentioned in my opening testimony, the vast majority of false confession cases have been in homicide cases, including 3 of the 4 false confessions here in Nevada. If the language was crafted, and be happy to work with Ms. Noble and her team to say that the homicide is imminent or the attempt at homicide is imminent, as I believe the language of the bill already encapsulates, I think that's a place that we could get to. But just wholly carving out any attempted homicide or any homicide that has occurred when there's no threat to harm to anyone in the investigation, that's something I think should be rejected, and no state has adopted that whatsoever. With those final comments, I thank for the committee's look at this issue and consideration of it.
Thank you so much, and we certainly appreciate you joining us this afternoon via Zoom, and everybody taking the time out of their day to answer questions, provide testimony, and engage in this conversation. With that, I will close the hearing on AB 193 and open the hearing on AB 309, inviting the presenters up to the front to go ahead whenever you're ready.
Good afternoon, Chair Scheibel and committee members, and thank you for the opportunity to hear AB 309. If there was ever a good time to present an HOA bill, I would think it would be right now after that heavy bill hearing. So hopefully this will be a little bit easier on your hearts and your minds. Today with me presenting is Mr. Garrett Gordon from Lewis and Roca. We've become quite the team when it comes to HOAs. And the irony in all this is I don't live in an HOA, and I never have. But it doesn't mean that I don't recognize good business practices and good constituent empowerment. So this bill is really the result of a constituent, and so I'm honored to be able to present it. This bill, I'll have Mr. Gordon, if it's okay with you, walk through the bill. But this bill truly is a win-win, not to be confused with Senator Wynn and Assemblyman Wynn. That is a killer combination when they're on 2 bills together. The bill does a couple of things. This bill will enfranchise more unit and homeowners for community elections, and it saves money and provides efficiency for associations in their operations, which in turn saves unit owners and homeowners on their dues that they pay for operational expenses. And thirdly, and it has an important due process provision for board members. So if it would be okay with the chair, I'd like to turn the time over to walk through the bill with Mr. Gordon.
Thank you, Madam Chair. For the record, my name is Garrett Gordon, a partner at Lewis and Roca. I'm here on behalf of the Community Association Institute Legislative Action Committee to present AB 309. I want to thank Assemblywoman Hanson for sponsoring the bill and Chair Scheibel for holding the hearing today and the committee for your time. AB 309 will really do 3 things. 1, encourage and increase participation in HOA elections. 2, give associations cost-saving options, and 3, ensure a more efficient, complete transfer of association records. There is a national trend to allow for electronic voting in HOA elections. Currently, 26 states, including Oregon, Washington, New York, New Jersey, Florida, Arizona, and Texas, allow electronic voting in HOA elections, which is no surprise since the data supports these laws, clearly support that these laws increase voter participation and reduce costs to associations and homeowners. As I go through each section, I'll provide some comments, and again, I'm happy to answer any questions at the end. Section 1 amends NRS 116.31034 to provide that HOA elections may be allowed an option of electronic balloting. Due to the NRS 116 requirements for staggered terms, elections are an annual event for HOAs. Currently, NRS 116 requires that each association produce, mail, and hand count paper ballots. It's a very expensive process, as each ballot requires 3 envelopes of different sizes, a paper ballot, and a page of NRED required disclosures and position statements for each candidate. This must all be assembled and mailed through the U.S. Postal Service. Ballots must be returned to the association within 15 days. The out-of-return envelopes are validated to ensure that the envelope can be identified to a unit and a unit owner. Then these return envelopes are opened at the annual meeting of the members, and the paper ballots are hand counted by a team of volunteers at the annual meeting. Typically, once all the secret ballots have been separated from the 2 envelopes in which they arrive, one volunteer will read out loud the vote while another makes tally marks on a piece of paper. Obviously, this is a very laborious process, and despite everyone's best efforts at hand counting, it's frequently inaccurate. At the end of the process, the results are announced and the new board is seated. AB 309 will provide associations with the option. Again, this isn't mandatory, it's an option. It's really giving enabling authority to associations to choose electronic balloting. They can either do it through an independent third-party provider or a voting machine like the ones used in state elections. If the association chooses an electronic balloting option, individual owners always retain the right to vote paper ballot. So absolutely, if you're a unit owner, you'd like to have a paper ballot, regardless if you're moving forward with an electronic election, you can always request that paper ballot. It's a rare HOA and a rare election when even half of the owners vote nowadays. Before NRS 116, owners had to show up at an annual meeting in person or by proxy to be nominated for a seat on the board and then vote. As you can imagine, participation was generally abysmal. Secret written ballots were an improvement in both convenience and democratic participation. AB 309 is a step down the path of increasing owner participation in the governance of their communities. While most of us pay less and less attention to our paper mail, we bank, communicate, and conduct our household business largely via email and internet. In recognition of this fact, this committee passed a bill earlier this session to make email the default method of communication. AB 309 will allow HOA members the option to vote electronically. The electronic voting options contained in this bill will allow associations to choose the process that's right for them by providing more efficient, cost-effective methods for conducting annual elections, while appropriate safeguards to ensure the integrity of the process. Section 2 incorporates these electronic balloting options into HOA removal elections as well. A removal election is how HOA members recall directors. Once owners submit a valid petition for the removal of a director, the directors are required by law to meet for the purpose of scheduling the meeting of the members at which the removal ballots will be counted and the dates on which the ballots will be disseminated to the owners. AB 309 adds an important option for a director who is a subject of a recall effort to request a special board meeting, presumably to make the case why he or she should not be removed. That meeting must be held at a meeting before the secret ballots are announced. This additional step of due process was important to the Assembly Judiciary Committee, making sure that that due process step for the recall election took place. Section 3 sets out the process for in-person and secret ballot votes by owners, as well as votes by absentee ballot and proxy. This statute specifically on how such votes are conducted and what type of information proxies and ballots must contain. AB 309 just clarifies that elections and removal elections are 2 types of votes which owners may conduct without a meeting. This is already the case, but the proposed amendment makes this clear. The bill also specifies the requirement for a voting machine and hours and times when that voting machine must be available to an association, if they choose that option. If an association wants to use a voting machine, it must be approved by the Secretary of State in accordance with NRS 293B, and once voting begins, must be available for use between the hours of 8 a.m. and 8 p.m. for a period of 15 consecutive days. Another Assembly Judiciary amendment clarified that the voting machine must be located in a prominent place within the common elements of the association. There was a concern on the Assembly side that the voting machine could be placed at the management office all the way across town from where the HOA and the homes were located. So a voting machine has to be now located within the common elements of that association. Section 3 specifies the owner's option to receive a paper ballot, again that stands, and sets forth the timeline for the owner to make the request, which is up to 5 days before the date on which the ballot is counted. If an association has opted to use a voting machine, an owner may opt out and again request a paper ballot. Finally, Section 3 also specifies that the association chooses electronic balloting, that the association must use a third party, and that no one, not the board, not the members, not the manager, not the owners, not the declarant, can have any access to the voting results before they're announced by that third party at a members' meeting. If you're wondering if there are any independent third-party providers that conduct online HOA elections, a simple Google search, you'll find that yes, there's multiple choices in the Nevada marketplace who could offer this service. This section also sets forth the standards for online voting system. It must have the ability to authenticate the identity of the owner, ensure the vote remains secret and is not altered in transit, provide each owner with an electronic receipt, and store the votes for later inspection by the ombudsman and owners. Count all lawful votes and reject votes that are duplicative or not from the actual owner. Section 5 extends an association's ability to make automatic payments for routine expenditures. Currently, an association may only set its utility payments for auto pay. AB 1309 would allow reoccurring bills such as insurance, internet, telephone, ombudsman payments, and other service to be on auto pay like most of us do in our daily lives. Section 6 amends NRS to require the Commission to adopt regulations on how to standardize how management companies transfer books. And Sections 8 through 11 just make these same changes to condominium hotels under NRS 116. So in summary, we strongly believe, and the data has shown nationally, that electronic voting increases member participation for votes and saves homeowners money from all the mailing costs of the ballot mailings. AB 309 was passed unanimously out of the Assembly Judiciary Committee, unanimously out of the Assembly, and respectfully ask that this committee does the same. And I want to thank the chair for holding a hearing on this bill. We greatly appreciate it.
And Chair, my apologies to the committee and to the committee secretary, Assemblywoman Hanson, District 32. It's not like you didn't have a big sign there to remind me of that. So thank you. We're open for questions.
Thank you very much. Are there questions from members of the committee? Senator Hanson.
Maggie Carlton was very fond of saying, don't let the perfect stand in the way of the good. But everything about this bill's perfect, I got to say. So thank you, Madam Chair.
Thank you. Any other questions? I just wanted to clarify something really fast. You mentioned an amendment in your presentation. Is that the amendment that was already adopted on the Assembly side?
For the record, Garrett Gordon, yes.
Okay, perfect.
Thank you.
Looks like you have escaped the hot seat. We will move to testimony in support of AB 309. Anybody wishing to give support testimony is invited up to the front to do so now. I don't see anybody coming up in Carson City or Las Vegas, so we'll go to the phones.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer support testimony at this time.
All right, then we'll go to opposition. Anybody wishing to give opposition testimony? I don't see anybody in person, so we'll go to the phones.
Thank you, Chair. There are no callers to offer opposition testimony at this time.
Okay, let's try neutral. Anybody want to? Oh, we do have someone to testify in neutral in Las Vegas. Please go ahead when you're ready.
Good afternoon, Madam Chair, members of the committee. Sharat Chandra, Sharath Chandra, Administrator for the Real Estate Division. just here in neutral, and happy to answer any questions if members have any. Thank you.
I don't see any questions at this time, so we certainly appreciate you being here. And we will see if there's anybody else wishing to testify in neutral on the phone.
Thank you, Chair. There are no callers to offer neutral testimony at this time.
All right, then that brings us to the conclusion of testimony. And even after all of that testimony, you have nothing left to add. So we will close the hearing on AB 309 and open the hearing on AB 454.
Good morning, Chair, members of the committee. My name is Marcy Riba, R-Y-B-A, and I serve as the Executive Director of the Department of Indigent Defense Services. As many of you know, we work with our rural counties to provide them with resources for our public defenders, as well as develop plans for the provision of indigent defense services to help these counties comply with minimum standards in indigent defense services. This legislature, knowing that compliance with those minimum standards would cost additional funding, allowed our Board on Indigent Defense Services to create a maximum contribution formula, saying that the board could set the maximum amount that each county would pay for the provision of indigent defense services. What we have before us today is Assembly Bill 454, and in the first part, it clarifies that money should be appropriated in the Department of Indigent Defense Services budget so that we can reimburse those counties pursuant to the maximum contribution formula. It also provides that if those funds are exhausted, the department can seek an allocation from the statutory contingency account so that we can reimburse those rural counties if the amount that we were initially appropriated wasn't sufficient to bring them whole. Next, what this bill does, it allows the board to adopt regulations to set those hourly rates for our appointed counsel in rural counties. Generally, in most cases, what happens, once counsel is appointed, it goes straight to the public defender's office. If the public defender has a conflict, many counties need appointed counsel to step in and act as the public defender. This rate that was set by statute has not been increased since 2003. And what the board would like to do in our rural counties is set the hourly rate at an appropriate rate for both indigent defense cases as well as post-conviction cases, which are a state expense. And I'm available for any questions if you have any.
All right. Any questions from members of the committee? Okay. I don't see any questions either. So thank you for your presentation. We will move on to testimony. Anybody wishing to give testimony in support of AB 454 is invited up to do so now. And I do see somebody coming to the table. Okay. No rush whenever you're ready.
It's that point of session, I guess. Thank you, Madam Chair. Vincent Guthrow for the record, the Executive Director of NACO, Nevada Association of Counties. Last name is spelled Guthreau. We appreciate the statutory mechanism here to provide those reimbursements for the costs above the maximum contribution, and we support this measure. Thank you.
Thank you. I don't see anybody else coming up to give in-person support testimony, so we will go to testimony in opposition to AB 454. I don't see anybody in person. Oh, I forgot to go to the phone. Is there anybody on the phone to give support testimony on AB 454?
Thank you, Chair. The lines are open and working. However, there are no callers to offer support testimony at this time.
It's like I knew. Let's go to opposition testimony on AB 454. Not seeing anybody in person. Is there anybody on the line?
Thank you, Chair. There are no callers to offer opposition testimony at this time.
All right. How about neutral testimony? Anybody wishing to testify in neutral today? Don't see anybody coming up to the table in either in-person location, so we'll go to the phones, please.
Thank you, Chair. There are no callers to offer neutral testimony at this time.
All right, then that brings us to the conclusion of testimony. And seeing no closing remarks from the presenters of the bill, I will close the hearing on AB 454 and go to the final item on our agenda, which is public comment. Anybody wishing to give public comment in person is invited to do so now, and I don't see anybody coming up to give public comment, so we'll go to the phones, please.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer public comment at this time.
All right, and that brings us to the end of our meeting. We do have a meeting tomorrow. It will be at 1 p.m. And until then, we are adjourned.